The zip ties bit into my wrists while Officer Campos read me my rights at my own front gate. Diane Keller stood 15 feet back with her arms crossed, phone aimed at me, recording. She was smiling. Not the polite neighborhood smile, the other kind. The kind that said she'd been waiting for this moment. Trespassing on HOA common property, she said loud enough for the phone to catch it. Criminal mischief. Threatening an HOA official. I have all of it documented. I didn't argue. I stood there in the October heat with my hands behind my back and let Campos walk me to the patrol car. Behind me, the gate I'd just installed, the one on my private driveway, 8 feet inside my property line, the one I'd surveyed twice and documented 6 ways, stood open and untouched. "Ma'am, you have the right to remain silent," Campos said quietly as he opened the rear door. His voice carried an apology his procedure didn't allow him to make. I looked at Diane one more time. She was still recording, still smiling. She had no idea what she'd just done. None at all. Let me take you back 4 months, to the morning this started. June. I'd been state senator for District 18 for 11 years. Before that, 10 years as a civil rights attorney specializing in property law. I'd written or co-sponsored 14 pieces of legislation during my tenure, but the one people knew me for, if they knew any of them, was Senate Bill 447, the Homeowner Protection Act. It reformed HOA governance across the state, required financial transparency, established appeals processes, set hard limits on fines and enforcement actions, created a state oversight board with real teeth. The bill had passed 3 years ago over intense lobbying from the HOA industry trade groups. It was the work I was proudest of. I lived in Meadowbrook Estates, a planned community of 200 homes in the northern suburbs. I'd bought the property in 2019, before the HOA formed, when it was still just a street grid and survey stakes. My lot was 1.4 acres, corner parcel, with a legal description I'd reviewed personally before signing. The driveway was mine, recorded, surveyed, unambiguous. Diane Keller moved in across the street 2 years later. She was HOA vice president within 6 months and president a year after that. She ran the association the way a warden runs a prison. Rules for the sake of rules, enforcement for the sake of power. I mostly ignored it. I paid my dues, kept my lawn trimmed, attended exactly 0 meetings. My work occupied 70-hour weeks during session, and Meadowbrook drama didn't make the priority list. The trouble started when I installed the gate. My driveway ran 40 feet from the street to my garage. The gate went at the 20-foot mark, right where the asphalt transitioned from public road approach to private drive. I'd had the property resurveyed in May. $800, Cedar County certified, filed with the recorder's office the same week. The survey confirmed what I already knew. Everything behind that gate was mine. I hired a contractor. The gate was steel, powder-coated black, 8 feet wide, with an automatic opener and keypad entry. It cost $4,200 installed. It looked sharp. Diane showed up the day the contractor finished. She didn't knock. She came up the driveway with a clipboard and that tight smile she wore when she was about to enforce something. "Eleanor," she said. She'd never called me senator, which I didn't care about. But I noticed, "We need to talk about this gate situation." I was in the garage organizing campaign literature boxes. I set down the tape gun and walked out into the sunlight. "What situation, Diane?" She tapped the clipboard. "You didn't submit an architectural modification request. That's a requirement for any exterior structure visible from the street. Section 9, subsection 4. And gates require board approval. We've denied 3 of them in the past year." I let her finish. Then I asked the question I already knew the answer to. "Diane, where's the property line?" She blinked. "What?" "The boundary between HOA, common property, and my private lot. Where is it?" The street. "The street is county property. I'm asking where my lot begins." She looked at the gate, looked at me. "The entrance to the driveway is part of the community aesthetic zone. That's defined in the covenants." I smiled. "Not the friendly kind. Show me the covenant language that applies to structures built entirely on a private surveyed lot." She couldn't, because it didn't exist. She left without answering. That should have been the end of it. It wasn't. The first violation notice arrived by certified mail 3 days later. It cited Section 9.4 of the HOA covenants, unauthorized exterior modification, and assessed a fine of $250, payable within 14 days. Failure to comply would result in additional fines of $100 per day and possible legal action. I read it twice. Then I pulled the CC and RS, covenants, conditions, and restrictions, from my files and read Section 9.4 in full. The section applied to structures visible from adjoining properties or common areas that alter the community aesthetic standard. There was no definition of where that standard began or ended. No reference to survey plats. No acknowledgement that private property had boundaries the HOA couldn't cross. It was exactly the kind of overreach SB 447 had been written to prevent. I drafted a response that evening. 1 page, 3 paragraphs. I cited the survey plat, attached a copy, and referenced the relevant section of state property code that established a landowner's right to improve their deeded land without HOA interference. I noted that the gate was installed entirely within my surveyed lot boundaries, and that Section 9.4 could not legally be applied to private property improvements. I sent it to the HOA's registered agent address and copied the full board. Diane's reply came back in 48 hours. It was not what I expected. The email, sent from her personal account, not the HOA's official address, accused me of hostile and intimidating communication with a board member. She claimed my reference to state property code was an attempt to weaponize legal language against volunteer community leaders. She did not address the survey plat. She did not cite any covenant provision that contradicted my position. Instead, she doubled the fine to $500 and scheduled a compliance hearing for the following week. I forwarded the entire exchange to my chief of staff with a 2-word note. Document this. The hearing was held in the Meadowbrook Clubhouse on a Wednesday evening. Diane sat at the center of a folding table with 4 other board members. 2 I recognized vaguely. 2 I'd never seen. There were 7 residents in the audience. 1 was my neighbor, Paul Hendricks, a retired engineer who had had his own ongoing fence dispute with the HOA. He nodded when I came in. Diane called the meeting to order and read the violation into the record. She showed photographs of my gate, taken from the street, I noted, and described it as an aggressive and non-conforming barrier structure that disrupts community sightlines. I let her finish. Then I asked if I could respond. "You'll have 2 minutes," Diane said. I stood. I placed the survey plat on the table in front of the board and pointed to the highlighted boundary line. This is a Cedar County certified survey completed in May of this year. It shows that the gate in question sits 8 feet, 4 inches inside my private property line. The HOA covenants do not grant authority over private lots. Section 9.4, which you've cited, applies to common areas and aesthetics visible from shared spaces. My driveway is not a common area. It never has been. Diane barely looked at the plat. The entrance to your property is part of the streetscape, which falls under community aesthetic standards. That's been the board's position for 5 years. Your position isn't supported by the covenants or by state law. I'm citing Senate Bill 447, which I authored, and which specifically prohibits HOAs from enforcing architectural restrictions on private property improvements that don't violate recorded deed restrictions. The room went very still. One of the board members, a man in his 60s whose nameplate read, Ken Rossi, leaned forward. "You're saying you wrote the HOA reform law?" "I'm the primary sponsor. It passed in 2021. It's in effect now. This hearing is arguably in violation of it." Diane's face flushed. "We're not violating anything. You're trying to intimidate this board with your political position, and that's not going to work here." I stayed calm. "I'm citing the law, Diane. That's not intimidation. That's how property rights work." She stood. "This hearing is over. The fine stands. If the gate isn't removed in 30 days, we'll pursue legal remedies." I collected my plat and left. Paul caught up with me in the parking lot. "She has no idea who you are, does she?" he said. "Apparently not. You going to fight this?" I looked back at the clubhouse. Through the window, I could see Diane still at the table, talking rapidly to the other board members. "I already am," I said. The next escalation came faster than I anticipated. 10 days after the hearing, I came home from a committee session to find an orange sticker plastered across my gate. It read, "Unauthorized structure. Removed by order of Meadowbrook Estates HOA." The sticker had been applied with some kind of industrial adhesive. It didn't peel. I had to use a solvent. That was vandalism. I documented it. Photographs, timestamp, close-ups of the adhesive residue. I filed a police report the same evening. Officer Campos took the report. He was professional, thorough, and visibly uncomfortable. Ma'am, I have to tell you, HOA disputes usually don't go through criminal channels. This'll get kicked to civil. It's vandalism of private property, officer. That's criminal mischief under state code. He nodded slowly. I'll file it, but I'd suggest talking to an attorney. I already had one. My attorney was named Marcus Levin. I'd worked with him on SB 447's drafting. He reviewed everything: the covenants, the survey, the violation notices, Diane's emails, the hearing notes, the police report, in under 2 hours. His assessment was blunt. You have an HOA president who doesn't understand the law and doesn't care to. She's operating on autopilot enforcement with no legal grounding. You can beat this 6 different ways. The question is how much damage you want to do. I told him I wanted it done correctly. By the book. No shortcuts. He filed a formal appeal with the State HOA Oversight Board, citing 4 violations of SB 447. Improper enforcement procedures, lack of covenant specificity, retaliation for legal objection, and vandalism of private property under color of HOA authority. We also sent a demand letter to Diane and the board requiring them to rescind the fine and remove all violations from my homeowner record within 10 business days. Diane's response was to call the police. That's how I ended up in zip ties at my own gate. She filed a report claiming I had forced entry onto HOA property by opening my own gate and had verbally threatened her during a confrontation that never happened. She attached an edited video clip, 30 seconds, no audio, showing me walking toward her in my driveway. I'd been carrying a bag of mail. The video made it look like I'd been advancing on her. Officer Campos arrested me because the paperwork required it. He was apologetic the entire time. I was processed, photographed, and released on my own recognizance within 90 minutes. Marcus met me at the station. This, he said quietly, is going to cost her everything. The charges were dropped in 48 hours after the prosecutor reviewed the full security camera footage from my house, which showed Diane approaching my property, me retrieving mail, and no interaction whatsoever. The threat was fabricated. The trespassing claim fell apart the moment the survey plat was entered into evidence. But the arrest was public record. And someone, I don't know who, sent it to the press. The headline ran 3 days later. State Senator arrested by HOA President in gate dispute. The article included my full statement, Diane's fabricated claims, and a detailed explanation of SB 447. By the end of the week, it had been picked up by 6 regional outlets and 2 national ones. The State Oversight Board accelerated its review. Diane was called to testify. She arrived without an attorney and spent 40 minutes insisting she'd acted within her authority. The board's ruling came down 4 weeks later. Meadowbrook Estates HOA was found in violation of SB 447 on all 4 counts. Diane was personally fined $2,500 for filing a false police report and barred from holding any HOA leadership position in the state for 5 years. The board was required to rescind all fines against me, update its covenants to comply with state law, and undergo mandatory governance training. The HOA's insurance carriers settled my civil claim, false arrest, defamation, vandalism, for $48,000. I donated it to a legal aid fund for homeowners fighting HOA abuse. Diane resigned the day after the ruling. She moved out of Meadowbrook 4 months later. I kept the gate. On a cool morning in November, Paul Hendricks came by with a 6-pack and a question. Did you know this would go this far? He asked. I thought about it. No. I thought she'd back down once she saw the survey. But she wanted control more than she wanted to be right. And now the law works the way it's supposed to. She gave me the test case I didn't ask for. Paul smiled. Hell of a way to prove a point. I looked at the gate, standing clean and unbothered in the autumn light. It's not about the gate, I said. It never was. It's about what happens when someone forgets that property rights don't end where their clipboard begins. He nodded, and we sat on the porch and drank beer and didn't talk about Diane Keller again. The gate still opens every morning when I leave for the Capitol. It closes every evening when I come home. It's mine. It always was. And now everyone knows it.